Welcome back in here to Live and Now from Fox. I am Andy Mack. Let's take you out to a top story that we're following since last week as we're learning new information about Hunter Biden's legal team quickly filing a motion for a retrial and then kind of taking it back, withdrawing that motion earlier on today. I want to put up this tweet right now from Reuters talking about this, saying clarification. The lawyers for Hunter Biden on Monday withdrew a filing seeking a new trial in this federal gun case moments after the motion was uploaded to the case's docket in Delaware federal court, according to a note on a court document. Of course, he is found guilty last Tuesday of these federal firearms charges for making a false statement in the purchase of a gun, making a false statement related to information required to be kept by a federally licensed gun dealer as well. All right, let's continue on here on Live Now from Fox and learn more about potentially what this means. We're going to bring into the conversation right now former federal prosecutor Neama Rahmani. Thank you again for joining us here on Live Now from Fox. And they quickly filed it and then withdrew it. Is there anything to this, Neama?
Andy, it means one of two things. Either they made a mistake and they're correcting that mistake, and that motion will be refiled soon, probably today or tomorrow, or they realized the motion had no merit, didn't make sense. And if you look at the substance of the motion, very difficult argument to make. And even if there was an argument, it would have been waived. This is what the defense is arguing. They're arguing that they appealed a decision by the trial judge, Judge Norica, dismissing the counts on Second Amendment grounds. That appeal went up to the Third Circuit Court of Appeal. The Third Circuit three-judge panel rejected the argument. Then the defense petitioned for hearing en banc. That means they asked for the entire group of appellate judges in the Third Circuit to hear the case. That is a discretionary appeal. The judges can decide to accept the case or not. Now, generally speaking, while a case is up on appeal, it divests or removes the trial court from jurisdiction to hear the case. But in this case, because it was a discretionary appeal and because the defense failed to raise it at trial, and they went through the entire jury trial, got guilty verdicts, and now we're raising the issue, I think it's been waived. And I still think it's not necessarily a good argument because, again, that appeal is discretionary.
Yeah, that is a very good point, just to kind of decipher what this potentially went into this, and good information there as well. I do have to ask you, if this was a mistake, as they weren't expected to do this, how much of a black eye, how much of an embarrassment is it? Or is this kind of common practice that sometimes you accidentally click the button to send something that you shouldn't have sent?
And it is a black eye. I mean, you're talking about federal court, one of the biggest cases, not the biggest case happening in the country right now. And to file an appeal that contains an error, or to file an appeal that contains an argument that, frankly, is not a good one, it's a black eye, especially for the defense in this case. Has made one mistake after another. The biggest mistake, of course, is blowing up that sweetheart diversion deal in the first place, pushing this case to trial, embarrassing Hunter Biden and his family when there was no real defense. And even that hometown jury, they returned a guilty verdict in 3 hours because it's clear that Hunter Biden is a user. He's an addict of crack cocaine, at least at the time he purchased his gun. So to put him through this very embarrassing and public trial was a mistake. And now in appeal, it appears the defense is continuing to make more mistakes.
Yeah, that is like you said, and we were watching some video from earlier last week as Hunter Biden there with Joe Biden as well, talking about this coming immediately after it as they met there on the tarmac. I do have to ask you about the appeal, and you also mentioned kind of the sweetheart deal that fell away. What happens next in terms of the appeal, and how quickly does that get going?
Generally speaking, a notice of appeal has to be filed within 30 days of the judgment, and that's within 30 days of sentencing. Sentencing, we think, is probably going to happen sometime in October. It might get pushed back, but the defense still has some time for the appeal. Now, they're going to renew their motions for a new trial. Those motions will be denied, but generally speaking, those motions at the trial court will be the basis for the appeal at the appellate level. And we know one of the arguments, of course, is the argument that they're making here, that the Second Amendment prohibits prosecution in cases like this. Now, the Supreme Court hasn't ruled it yet, but we are seeing a shift in some courts that are saying, listen, just because you're a former drug addict doesn't necessarily mean you can be prevented from owning a firearm. There's at least one Fifth Circuit decision there in Texas that has held that. We know the Supreme Court a couple of years ago said that some of these gun laws that are being passed by states are overbroad, and there's a case that the court is hearing right now that relates to former domestic violence offenders or folks that have been convicted of domestic violence in the Rahimi case. Can they be barred from holding a firearm? So it's an argument on appeal. And of course, we know that they're going to try to enforce that original plea agreement. They're going to argue selective or vindictive prosecution. And now a fourth argument tends to be this jurisdictional issue as well. They're going to throw everything at the wall and just hope that one of those arguments sticks. I think it's unlikely, though.
All right, that is very interesting in terms of the timeline. I do want to ask you is, we're getting a lot of headlines, and Karine Jean-Pierre, the press secretary at the White House, confirmed today that they said that President Joe Biden would not commute the sentence of Hunter Biden. And we've talked about how maybe the Biden name makes this case more high profile, but it also maybe doesn't set precedents for it. Maybe in terms of the commuting a sentence, how frequent does that happen? And is that a rarity at all? Although they said they won't do it. Can we get some background into this?
It does happen. Presidents have the right to pardon or commute sentences. Obviously, I've been saying all along, it's very different to say that Joe Biden will not commute his son's sentence when he's in the middle of a contentious presidential election, and that's going to be a hot button political issue. And when Hunter Biden hasn't been sentenced to prison time yet, and he's still facing another more serious trial here in Los Angeles, where I live, on tax crimes in September. So if Joe Biden loses, if Hunter Biden is indeed sentenced to prison, both in the gun case and or the tax crimes case, it might be a very different Joe Biden on the way out that may strongly consider pardoning his son entirely or commuting a sentence. So easy to say one thing now when there's no real possibility of prison time, at least not yet. And Joe and obviously Donald Trump are headed to a debate next week. And certainly it would be an issue if indeed Joe were to say that he was going to pardon his son Hunter. So let's see what happens after November. I think that possibility may certainly be on the table.
Yeah, that is very, very good to note as well. And potentially Trump could ask for a pardon himself coming up there and the other case as well. All right, but very, very interesting. Neama, I just wanted to get your clarification today because we watched that the motion withdrew there for a new trial in Delaware. Thanks again for your time here on Live Now.